your case?
Yes, ma'am.
Okay. And was he able to ask you questions, and were you able to answer them? And was it a full, in-depth, and direct conversation between the two of you?
Yeah, we had plenty of time to talk about it. He understands exactly what issue that we're dealing with, and he, at this time, would like to go ahead and waive his presence at any jury meeting.
Mr. Harris, you've heard what Mr. Kilgore had to say about y'all's conversations. Do you agree or disagree with what he just said to me?
Oh, yes, and I agree. I do waive my right to be in attendance.
Okay. Have you had adequate time to sit down and thoroughly discuss this topic with your legal counsel, of which there are 3? Have they been available to you for making this decision?
Yes, ma'am.
Has it been a thorough and complete conversation in your opinion?
Yes, ma'am.
Have you been able to ask them questions both about factual decisions and legal decisions as it relates to this issue?
Yes, ma'am, I have.
Have they been available to you and direct and forthright in giving you their legal and strategic opinions on this issue?
Yes, ma'am.
Are you satisfied with the time you've had to speak with them?
Yes, ma'am, I am.
Are you satisfied with the quality and the content of those conversations?
Yes, ma'am.
You need to just specifically tell me what your position is with regard to attending any viewing of the vehicle. Do you want to go or not?
Oh, I do waive my right to attendance. Yes, ma'am.
So, do you want to go or not?
I do not.
Does the state have any questions or issues or areas that you feel I haven't adequately addressed? I'm open to your thoughts.
My only suggestion would be that, obviously it kind of goes without saying that we're having this dialogue, that if the defendant indicated that he wanted to go, I assume the court would be inclined to find some suitable requirements that would allow him to be there. And I think that's kind of self-evident by the line of questioning, but we might want to be explicit about that.
Well, I'll be explicit about that. If for any reason at any point Mr. Harris changes his mind and desires to be present, it just needs to be called to my attention, and I'll address it and work on it and develop it. Mr. Harris, I know you sat down. Did you hear me say that?
Yes, ma'am.
Okay, so you understand that if for some reason you have a change of mind, you need to call that to my attention.
Yes, ma'am.
You can do that through your counsel. Do you understand?
Yes, ma'am.
Anything else for the state on this topic?
No, ma'am.
Just this narrow topic?
Not for that narrow topic.
On that narrow topic, and then for the defense on this narrow topic?
Not on the waiver issue, Judge.
All right, Mr. Kilgore, it's your responsibility if at any time there is a change of mind about this that you let me know. Oh, Mr. Harris, I want to ask you one more question. Are you satisfied with your attorney's representation of you on this narrow issue?
Yes, ma'am.
Now, I have the order that's been prepared by the state, and it's a draft, and I've reviewed it. It's been given to the defense. The defense still objects to conducting the view. I'm going to stand by my prior ruling allowing that. Our conversation here now about this order and about the practicality and logistics of the jury view does not constitute a waiver by the defense of their position in that regard. That being said, I think we can go forward and start talking about it. Have you had a chance to look at the proposed order, Mr. Kilgore?
Yes, we have.
Have you had a chance to confer with, you can be seated, but unless you just want to stand. Have you had a chance to talk to the state about this?
Not really.
Well, that's fine. Do you want to talk to them some more?
I don't think we're going to really come to any agreements because we're objecting to the whole procedure, but I've let them know specifically what my concerns were.
Well, let's go item by item.
And I believe that they have procured the primary one, which was Ross not having to be present, and the secondary one, which was I didn't think it was appropriate to have a view in an enclosed space, such as a shed or garage.
Let's go item by item. Bullet point 1. The defendant's vehicle shall be transported to the Boone County Superior Courthouse. It shall be parked at a location designated by the sheriff of Boone County for the jury view. I take it, Mr. Evans, that you have discussed this with the sheriff and they find that acceptable.
Yes, ma'am. We started off initially discussing that with the idea that the defendant would be present. The only reason that we changed and modified that to discuss moving to enclosed areas because of some of those security concerns. But now that that's not an issue, I had my investigator reach out to Major Lewis and confirm that there are at least 2 locations they're considering here at the courthouse where they could bring that vehicle that they believe would be suitable. Obviously, there need to be some further instructions to the media about not filming any jurors because they would be visible. But they've come up with a couple of ideas, and we're working with them on that.
All right. What is your position on bullet point 1?
Well, Judge, I guess my initial concern was the fact that there would be media and cameras and whatnot present if we did it at the courthouse.
Y'all are putting the cart ahead of the horse. The media is the secondary issue at this point. It's a concern. I have thoughts about it, but I don't want you lose clarity and things become muddled when you introduce issues that I'm not talking about. I don't mean you specifically.
Okay.
I mean you figuratively.
Okay.
It's a philosophical thought about how you analyze problems.
Okay.
Therefore, let's not talk about the media now. So, if you forget about the media, what are your concerns about your bullet point 1?
Where?
What do you mean?
Well,
Bullet point 1, what do you consider?
courthouse is
Oh, you mean
2
where is
blocks.
it, where is it going to be located?
Yes, ma'am.
Well, I don't know. Why don't we see what the sheriff suggests, and then if there are concerns, we can address them then. Other than that, what are your concerns about bullet point 1? Location is valid. I think we need to hear from the sheriff what the suggestion is. It may be a perfectly fine suggestion. It may raise some concerns. The time for raising concerns is when we identify a specific location. Fair enough?
Okay.
All right. So it looks like 1 is okay, but let's make a note to discuss location when the sheriff suggests which one they like the best. Okay. Bullet point 2, what says the defense?
Part 2 is contrary to the motion filed by the state April the 11th, 2016, and is contrary to the court's order ordering a jury, authorizing a jury in that it apparently says that State's Exhibit 307, which is the child safety seat, can be placed in the vehicle in the precise location documented during the processing of the crime scene. That's not at all what was discussed in the state's motion, which was filed back in April, nor is it addressed at all in the court's order. The car seat is in evidence, and it's our position that if we now start taking evidence and putting it in the car, we're manipulating the evidence. We're absolutely going to object to it. This has not been previously litigated. It has not been discussed. It's not been ordered by the court. And again, I will go back to at the real heart of it. My concern is that this is inviting jurors walking up to the car to substitute their view, what they can see, their view of the car seat, for what Ross saw or may have been in the position to see. That's inappropriate. That's not how the jury's supposed to be making the decision on a piece of evidence. And if we put the car seat in there, that's exactly what we're doing. And so that's my big, enormous concern on position 2.
Okay, then that takes me back to the first line of the proposed order that says with the consent of both parties, that needs to be stricken. Okay, now, coming to bullet point 2, I'd like to hear the state's argument.
Judge, this was a part of the argument we contend that was litigated previously during the motions hearing. We articulated, Mr. Boyne did, that the purpose of this was to allow the jury to see the crime scene. The crime scene is that car seat in that vehicle. Otherwise, you're seeing an altered crime scene. You're not seeing it as the crime was committed. I'll note for the court that there's been a heavily litigated case for the past several weeks. Crime scene personnel have been questioned extensively about the placement of the seat, its location, and about exactly where it is, and what you can see and what you can't see, and those types of things. Right now, just looking at that vehicle, it is an altered crime scene. It is not the crime scene as investigators found it, as the defendant found it from the date of the alleged offense. And putting that car seat back is no more prejudicial than the other information that's already been brought out before this jury through the testimony of crime scene investigators and through photographs and videotape that's already been played for them. All we're asking is that they see an unadulterated, unchanged crime scene pursuant to your prior order that will allow the jury to see that. And we think that that's appropriate in this case. We certainly have put in ample testimony that can be perfectly, precisely recreated. I'll note, too, that the defense has strongly objected to certain 3D animations or certain 3D scans that were performed of this. Hey, if there's any question about that, seeing the car seat itself in the vehicle will certainly allow the jury to do a comparison of the 3D scans that were done in this particular case as compared to what was actually seen and observed by crime scene investigators as they found this crime scene on June the 18th of 2014. So we'd ask merely that they allow to place the crime scene as it was in that the car seat will return. I will note that there's a sentence there, and I know I'm not supposed to muddle things, but we have absolutely no objection to the defense viewing that and going out with our crime scene investigator to make sure that it's accurately placed prior to the jury view as well. We have no problem with that.
Oh, I don't see that as muddling. It's specifically delineated in bullet 2, so that's, I don't have a problem with that. Okay, do you want to say anything else, Mr. Kilgore?
I think we made our statement there.
I think you both made your argument. Bullet point 2, I find acceptable. All right. Bullet point 3. What says the defense?
There's nothing specific about that statement that I take a position on one way or another, Judge.
How are you going to decide how the door is going to be open? What positions? Was it fully open?
It was, Judge. We plan on just leaving the car door fully open before the jury even arrives for the jury.
Okay. Then put it in there with the driver's side door fully open.
I guess, Judge, I apologize. Let me just put on the record, based on what Mr. Evans just said about this being a crime scene, put it back in the state that it was, if that were all so. The door was closed. The door was in fact closed. In fact, the indictment itself speaks to that fact. So Mr. Evans is concerned about altering the quote crime scene. Having the door open would be an enormous alteration and amendment to the quote crime scene. So I guess to that extent, we would agree with him. It would not be appropriate to have the door open because that would be altering the scene.
You have the door open, but it needs to be fully open.
Excuse me.
So that means your open becomes an opened ED. Okay. Bullet point 3.
I see I need to remove the word independent.
I'm sorry.
Oh, I'm sorry. No, I'm incorrect about that. I had that on purpose.
What line are you on? I don't see any problem. What says the defense regarding bullet point 4?
We want to make very clear that there are no trial witnesses in eyeshot of the jury, including any law enforcement officers.
You mean any witnesses from this case?
Yes, ma'am.
Okay.
Which would include Detective Stoddard or any other law enforcement person.
He's been accepted from the street. Well, all right. What do you say about that? I mean, there's going to be law enforcement there, but they're going to be Glenn County. Clearly. Yes, sir.
Because Detective Stoddard has been exempted, we ask that he be allowed to remain with us. We'll instruct him not to speak to us. We're not going to interact with the jury or anything like that, but we ask for an exemption for him because of the placement of when we intend to doing this during the presentation of the state's case, we don't expect that that will be an issue. There should only be one or two witnesses remaining at that point. From the state's perspective, it would just be incumbent upon the defense to instruct their witnesses not to be anywhere near this, because we think that we'll have already presented our law enforcement officers by that time.
Well, I've accepted Detective Stoddard, and I'm gonna stand by that, and he can be present, and stand with the prosecution team. Otherwise, I see bullet point 4 as being fine. It might be a good idea to add language here about where designated places for the defense and the state to be, unless, let's see, is paragraph 5 going to cover that?
It does not, Judge.
Yeah, I didn't think it did, or I think it alludes to it, but it doesn't specify. I think that would be fair to say.
Depending on, I know the precise location that the sheriff's office is contemplating for these two. I just didn't want to mention it on camera at this point for various reasons, but I feel confident that we'll be able to speak to the sheriff's office and probably come to some sort of resolution depending on which of those two they deem most appropriate. And if I need to add specific language to bullet point 4, I'm happy to do so once they've made that decision.
What's it for? Well, your last sentence may solve the problem I just raised. It's not as tight, precise, and detailed as one might be able to craft. But it says no party shall interact with the jury during the jury view. You could add language and shall stand a certain distance from jurors. What do you think? How many feet?
I think knowing the location and the sheriff's office concerns about that would be a precursor to knowing the estimated distance that will be away from them. But I don't have any problem adding that language, Judge. I agree it could be more precise. This is sort of generalized because we were waiting to get a little more information from the sheriff.
Just say this, the parties shall stand in an area designated by the sheriff.
Yes, ma'am.
And then if y'all got any problems with where you're standing, call it to my attention. And the last one, I don't think I asked your opinion on 5, Mr. Kilgore. What do you say?
Respectfully, Judge, we're sort of light on a couple of details during this discussion.
Mhm.
It's really the details that we probably would have comment on and be concerned about. So I think this is good for us to have this discussion now, but until we know precisely where and precisely the distances we're talking about between jurors and counsel or jurors and the vehicle.
That's all well and good. I don't plan on signing this until everything firms up. Something like this can legitimately take place in stages. I see this as more than preliminary, but I don't see this as final. And the conversation needs to be begun so that it can firm up.
Yes, ma'am.
So I think once we know where the sheriff wants to place it, then we'll see if there are concerns and we can tighten up some language. But I think generally this is fine.
Why don't I reach out to the sheriff's office and see if they can either be here first thing in the morning or during our morning break?
Well, I think the sheriff's already communicated he wants to meet with me.
Okay.
And I intended to meet with all of y'all with him. And I think this morning is good because he had a funeral this afternoon. So I think to some degree he's already been asked about that. Can y'all follow up and see if he can come in the morning?
Yes, ma'am.
Thank you. That's done. Okay, court reporters. It says, court reporter will be present for jury view and all objections shall be reserved until after the jury view at such time. Any problem with that language?
think the law is squarely against that. Esposito, 273 Georgia, 183 is very clear that we're supposed to have a court reporter there. But I would make an additional request. I think it needs to be videotaped. I don't think the court reporter is going to be able to pick up the dynamics of what would be going on while jurors are outside of the courtroom and viewing the motor vehicle. So I know we've got David Tyler available to come down here from the county. My request would be that the court order and direct that it be videoed.
Judge, I don't have a problem with just trying to just lessen the burden on your court reporter, but if they're insistent that they want the court reporter out there, I don't expect that there'll be anything to take down, but the state doesn't object to having a court reporter out there. I do think it would be cumbersome and burdensome. I also think it would be disruptive to have the proceedings videotaped, particularly by David Tyler or anyone else. David Tyler, by the way, works for TV 23, which is a media outlet, and we've already told the jurors that they're not to be filmed, they're not supposed to be filmed. So I've got grave concerns about them being filming and how that might impact what they're tasked with doing during the jury view process. But as to the court reporter, if we can sort that out and find a way to get a court reporter out there, then I have no objection to that.
All right. Well, we'll need a court reporter out there. Mr. Tyler, he's not here, is he? No. So I'm not going to do that. And a videographer, I don't see. You could end up with a piecemeal record in that way. So I'm going to deny that request. Okay. All right, now let's talk about the media for the view, and then we'll have to come up with a charge as well, and we have an evidence issue. Evidence, charge, media. And then we'll meet with the sheriff in the morning and fine-tune where the vehicle will be and where the parties will stand. From an evidence point of view, is the vehicle, are you going to put it in evidence? How do you plan on doing that?
No, we've had a discussion about that. I mean, while it is a piece of evidence, just as a crime seems a piece of evidence, it's not something that's actually going to be tendered. I don't think it needs an exhibit sticker or anything like that. You know, if the court feels strongly one way or another, I would welcome insight, but we had that discussion. We simply don't believe that it's a piece of evidence similar to something that's brought in and actually tendered in court.
How do you anticipate preserving it?
I'm sorry?
How do you anticipate preserving it?
Well, it's currently being housed by Cobb County Police Department. They've had it preserved at their evidence shed. I think it's been preserved there for years since this happened. So I would assume that until the conclusion of any appellate work, if there is, that we'll find some way to continue to preserve it in Cobb County's evidence unit. It's really no bit different than a jury view where you go to a house or something like that. You wouldn't necessarily tender a house or even be concerned so much about preserving the house. I suppose the house could be demolished afterwards. But out of abundance of caution and for posterity, whatever that may be, I do expect that we will keep that vehicle until the full conclusion of this case, whatever that may be.
Well, a house is totally different than a car because a car can be moved about and a house is much more difficult to do so. But otherwise, your observations are correct. It's also an item that if either party wishes to mark and tender into evidence, they can do. So it's really it's parties' decisions whether to do that, not a court decision. So I'm not going to get involved in that. It's just something to be aware of. And if it does, the clerk has got to have something in writing about the disposition of the item if it becomes evidence. At this point, you're not anticipating it to be. It may become at some point in the future. If that's the case, we'll cross that bridge. But it's something I'm concerned about. So I think I've had a good enough answer that I'm not. If we get there, we'll deal with it. Meet in order. And if y'all don't tender it, it doesn't come into evidence, then that becomes a non-issue. So I'm satisfied there. Now, I'm going to have to charge the jury when we do that, and I will work on some language, or you all can submit some language to me. It's an invitation to you all. I think your bullet point 1, 2, 3, 4, 5 probably sets out a lot of it. I'm a little shorthanded, I don't have a staff attorney, but I've asked them to get me in charge. There's not a criminal charge, I don't think, pattern, but there is a civil one, which I've used in the past when I've done civil litigation. But I'm gonna have to have some help getting the research done, because I've brought my criminal pattern and jury instructions. I don't have my civil. Maybe I can do something over the evening, I don't know. I'll work on it, but you're welcome to submit something if you want to.
You don't happen to know what that civil charge is, Judge? We have electronic versions of both civil and criminal, so I'd be happy to take a look at it if you happen to know the charge number. Obviously, having done no civil law in my career, I would not know where that is.
Well, actually, the one where I used it was about a house.
Okay?
Since we're talking about houses, they went out to look at a house with a roof that went like this to see if the homeowners needed to pay for the roof or not. So I think it's under, view, it's gonna be either under view or seen. It'll be in the civil book,
That's a good enough start for us, Judge. We'll see if we can find that this evening.
because that's where I was gonna look.
Yes, ma'am.
All right, well, everybody's invited to present whatever they want, and I'll have something from your submissions. Now, let's talk about the media. Mr. Sharon, this is gonna be your task to interface with them. To me, the important points are that no jurors are to be depicted in any way by the media. And then the other issue to me is that their distance needs to be properly established. Those are my two concerns. And I know that you can work with them to make sure that they have access to doing what they need to be doing, but that the juror's identity is protected, and that they aren't in a position where, I don't want the jurors more aware of them than what they're looking at.
I understand.
What does the state have to say about all this?
That's fine, Judge. I think you've addressed our concerns, and I trust that you'll adequately inform them through Mr. Sharon that they're not to view this. Of course, we'll be able to give them, I don't want to broadcast it publicly, but when we know the precise location, so there's no inadvertent filming, we can tell them this is the area that's absolutely off limits.
Okay. Well, I think that we need to let the media know when and where, see what their thoughts are about a setup. I want a full camera. I don't want a bunch of cameras, just one, because I know y'all are listening, because I see you thinking. I want one camera, so y'all are going to have to pull, and then you can work with Mr. Sharon as to where you want to place it, and then I'll look and see if I'm comfortable with it. Although so far I have no reason at all to believe I won't be, because you all have just been very appropriate with everything you've done, and that's appreciated and noted. So one camera, I'll let y'all know when and where. You all can interface with Mr. Sharon as to where you want to place that camera. If there are any concern, we'll all get there in advance of the jury being brought, and everyone can voice concerns at that time, and we can work on something, and I'll make decisions as needed. And after that, then we'll bring the jury up. I think that'll work. Mr. Kilgore, what do you say?
That's fine with me. I don't really have a position on that one way or the other.
Okay, because your input is welcome too. Invited. Okay, so you can take care of that? All right, we'll meet with the sheriff in the morning. Any other issues regarding this with the state,
No, ma'am.
with the defense?
Not at this time.
And Ms. Deputy Moore, can you let us know if the sheriff can meet with us at 8:30 in the morning?
Yes, ma'am, I have Major Lewis on his way now, so he could talk to him before we get out of work.
Brilliant. Okay, so we'll try to get that firmed up before we leave today. Anything else before we send for jurors?
Can we have 2 minutes to run the restroom real quick there?
You run?
Thank you.
Okay. 1001, 1002. Kathleen, what do you have that you can tell? Oh, there's nothing in it. So just be like a lawyer in an office taking depositions.
Yeah. Well, usually.
Oh, here.
So,
There you go.
Mr. Evans, when you start looking for that, it's gonna be in the tort charges. About the view?
in the court charges.
Tort.
Tort. Yes, ma'am.
I'm sorry. It might be under contracts too.
Okay.
Are we ready?
Yes, ma'am.
Bring the jury.
That's all right. Watch your step. Please be seated.
Ready, you can resume.
All right, we left off talking about Detective Sean Murphy. And I believe the last thing we were talking about was if y'all were located in the same area of the Crimes Against Persons Division back in summer of 2014.
Yes, sir.
And I believe what you said was y'all have the capability to apply for search warrants online.
That'd be correct.
Okay. And so the jury will understand, Crimes Against Persons, police headquarters is not located where the magistrate court is, where the magistrate judges are located, right?
No, it's in a separate building,
Couple blocks away or so,
a few blocks.
right? Those magistrates are there, somebody's there usually 24 hours, right?
Yes.
Okay. And what y'all can do is, when you want a search warrant, you can actually get, in the comfort of your own office, you can get in front of a screen and make application for that warrant. You can see the magistrate and he can see you.
That's correct.
Right. And when you do that procedure, you actually type out what is called a warrant application. Is that correct?
That's correct.
Okay. In the warrant application, you're setting out facts that you're stating are true and correct. When you file that with the magistrate.
Correct.
Okay. And then if the magistrate wants to hear any additional testimony from you, you can actually do that from your very office.
True.
Okay. And in this case, what we've just heard, or what you've agreed to is, a whole bunch of these search warrants were done by Detective Murphy.
That's correct.
Okay. You did some yourself.
Towards the end, yes.
Okay. Is there a reason why he stopped doing them and you started doing them?
Because it had been a certain time frame. Search warrants I did were at towards the very end of the investigation.
Okay. So if we want to ask Sergeant Murphy about, Detective Murphy about any search warrants that he was involved in, we just have to ask him.
Yes.
Okay. Now, if you become aware of any, shall we say, misstatements or errors in the case that become part of the case file, do you have a mechanism by which to let anybody know about that?
Let who know about that?
Well, let's just say, for example, if you learned that there was a search warrant that had some erroneous information in there, is there a mechanism for you to note that in your file, make a report of it, or bring it to anybody's attention?
Yes.
Okay. And what is that procedure?
You can do any of the above. If you find a search warrant that has erroneous information, especially if the case has already been sent or, the person has been arrested, the DA's office can be contacted. You can ask for legal advice. We're not lawyers. You can ask for legal advice about what, the next steps could be. You can also go through and take out another search warrant, explain to the magistrate you're taking another search warrant out for the same piece of equipment for a different reason, or not for a different reason, but to expand or clarify any information in that search warrant.
Okay. And in this particular case, you didn't go through any of those procedures, make any such notations in case. In particular, any error in the search warrant application. You didn't go back and do any of those procedures in this case to make a note to the file or notify the magistrate that there had been any errors.
I'm allowed that over objection.
DA's office was notified, and subsequent search warrants were taken out.
Okay. The DA's office was notified there were some errors or misstatements in warrant applications?
It was not worded the way I would have worded it, or clearly as I would have worded it. It could have been worded better, I think would be the best way to put it. And so the warrants were rewritten for the same piece of equipment and taken out.
And warrants, that's something that's actually filed once the warrant is signed. The application of the warrant, that's filed with the clerk, and that becomes part of public record, doesn't it?
I believe so.
All right. Did you have a chance to listen to that real short recording of your interview with Wesley Houston?
I did.
So if I could circle back to that real quick, I just want to clarify a couple of things. And again, Wesley Houston was the young on the afternoon of the 18th of June with Ross leaving the building, right?
We did.
Okay. And the person that would have been sitting to his right, that would have been Wesley Houston.
Correct.
Okay. And specifically as to what you learned during your investigation, and speaking with Mr. Houston, he never told you that Ross had told him that he was going to a movie.
No.
And he never told you that Ross said he was meeting Winston Mullins.
No.
and he never described Ross's statements to him as like making a public service announcement when he was leaving.
No, sir.
Okay. What you learned was that, in fact, Ross's wife, Leanna, had come in to the treehouse a little bit later, and she had notified Wesley Houston, my husband's name is Ross. I think he was supposed to be going to a movie with Winston Mullins, I think.
Yes, sir.
And Mr. Houston indicated to you that he had actually checked the computer records when Ross's wife gave him that information.
Yes.
All right, so I want to ask you more briefly about another part of the interview with Ross that we've heard a little bit about already. So as Ross was describing to you the events of the day, and we got to see that interview previously. He told you that he had gone to lunch with some friends.
Correct.
Okay. And that they picked him up.
Correct.
And again, it certainly couldn't have been a secret to anybody working in that building that there was security cameras all over that parking lot, right?
No more visible security cameras in the parking lot, yes.
And he told you specifically that he went to Publix for lunch.
He did.
Now, we had a little testimony yesterday about Ross throwing out a Publix receipt in the trash can while he was in the interview room.
He did.
Okay. And you would agree that shortly thereafter, after he threw out his receipt, he promptly told you that he had been to lunch at Publix?
Yes.
Okay. And that's true. You found out that was true.
It is true.
Friends did come pick him up. He did go to lunch at Publix.
Yes, sir.
Okay. Now, as you recall, certainly, that when you previously testified about this issue back in July of 2014, it's fair to say what you testified to, that it was impossible, or it was an impossibility that Ross forgot to tell you about dropping off the light bulbs in his car.
Can you tell me what page that's on?
82 through 83.
Go ahead, sir.
You don't remember that testimony?
No, I have it in front of me. Go ahead.
Okay. On page 82 there, you see I specifically asked you, you agree it's certainly possible that he forgot going to the Home Depot to get those light bulbs?
Correct.
You said no.
I did.
And I said, you don't think it's possible? And your response was what?
I don't think it's possible at all.
And there's a little more discussion about that, but at the end of the day,
There is.
that was your testimony.
Yes, sir.
Now, you agree that on that day that Ross gave his interview with you, that would have been an incredibly stressful scenario, really, for anybody. He'd just been arrested, he had the death of his son. I mean, it was a stressful situation, wasn't it?
Quite possibly very stressful.
Okay. And the interview was within just a couple of hours of finding his son and being arrested.
Correct.
you never specifically asked Ross if he had taken any side trips on the way back from lunch.
I did not.
He just basically sort of in a prose form just kind of told you what had happened during the day.
Correct.
And that included going to Chick-fil-A.
Yes, sir.
And he was telling the truth about that.
Yes, sir.
All right, so the trip to the Home Depot to get light bulbs, you've actually obtained, and when we say Home Depot so the jury will understand, this is a Home Depot store. It's not the Home Depot headquarters where these guys work, right?
No, it's one of the retail stores.
All right, and in fact, this store is kind of on the other side of Cumberland Parkway from where the Chick-fil-A is,
Yes,
and where the Publix is.
right across the street.
So they left Publix and it had been literally right across the street to go to Home Depot.
That's correct.
Right, but you agree. There were actually 3 people that made that trip to the Home Depot store.
Yes, sir.
Ross, Winston Milling, and Alex Hall.
That's true.
All 3 of these men were interviewed within 2 days.
That's correct.
Okay? But you agree Ross was not the only one of the 3 who didn't mention the side trip to Home Depot to get light bulbs.
That's correct.
Winston Milling was interviewed maybe a little more than 24 hours after Ross was. And you agree Winston Milling had completely forgotten that they had gone to Home Depot, got light bulbs.
I'm not going to say whether he forgot or not. He did not bring that up in the interview.
Okay? Let's take a look. I could just have one moment, Jay.
Yes.
You recall in interviewing Winston Milling that when he told you about what they had done that day, initially he left out completely going to Home Depot.
Yes, sir.
And in fact, y'all had to call to his attention. You said, didn't you go to Home Depot?
That is correct.
And what was his response?
He stated that they did not.
And then when you reminded him that they had gone to Home Depot, what did he say?
He only said he's not paying attention when they drive. Detective Stoddard asked Milling if they stopped anywhere else. He stated no. Detective Stoddard then asked if they went to Home Depot. He stated that they did after they left Publix. So they did after they left them.
So Winston Milling, 24 hours or so after Ross was interviewed, 2 days after he'd been to the Home Depot at lunch, he had forgotten.
Yeah, he did not mention it.
Okay. And it wasn't until you specifically asked him, didn't you go to Home Depot? He said, oh yeah. And he recalled at that point that he had gone to Home Depot as well. Isn't that true?
It's true.
And in fact, Winston Millen didn't just stay in the car. You've got video of him. He actually walked into the Home Depot store with Alex and Ross when they bought the light bulbs.
That's true.
And it's fair to say that it's highly unlikely that Winston Milling was under the same kind of stress that Ross would have been. Is that fair to say?
I would say it's fair to say.
Okay, I mean, Winston wasn't in custody. He hadn't been read Miranda rights. He wasn't a suspect.
True.
He had lost a child.
True.
A lot of factors.
Very true.
And yet he forgot too.
Yes.
But you don't think it's possible that Ross could have just simply forgotten that they had stopped by the Home Depot to get light bulbs?
All things being equal, he went back to his car at lunch, he opened up the car door, and he put the light bulbs in it. It is highly unlikely, in my opinion, that he forgot. In fact, when he's asked about his day, he stops at the point where he puts the light bulbs in the car at lunch. So, for myself, it's highly unlikely. All things being equal, is it possible? I would have to admit it is possible. Very highly unlikely.
Winston Milling forgot.
Winston Millen didn't go back to his own car with his child dying inside.
I'm not asking you about going to the car. I'm asking you about going to Home Depot.
And I'm stating, part of my answer is yes, he did. But there were other triggers that he didn't have that the defendant did.
All right, well, I'm not asking you about triggers. So let's get back to the preliminary hearing on July the 3rd, 2014.
Yes, sir.
When you testified that it was impossible that Ross forgot, you didn't notify the magistrate that one of the other two guys had also forgotten they'd gone to Home Depot, did you?
Myself personally, I did not take out any search warrants prior to the PC hearing.
You didn't tell the magistrate on July the 3rd that, yeah, another one of the guys also forgot going to Home Depot?
No, I did not.
I want to talk to you briefly about another video, the parking lot video from lunch. All right, so we saw a video yesterday, actually I think we saw two, that where Ross is dropped off after lunch at his car, and see him open the car door, put the bag in the car, close the door.
Correct.
And you've timed that before,
It has been.
so you agree it's less than 5 seconds.
I don't have the exact time, but yes, very quickly.
All right. And you agree that what we see in the video is when he opens the door, puts the bulbs in, closes the door, there's no lingering or stopping or hesitating, anything of that nature. The door closes and he immediately walks away.
Correct.
Now, you touched on this some yesterday, and I know it's something that you want to address. But when you testified back in 2014,
Yes, sir.
you agree that what your testimony was is that he opens the driver's side door,
What page are you on, sir?
2748.
Yes, sir.
Testify that he opens the driver's side door and kind of tosses the light bulbs inside. He's all the way inside the frame, so he just kind of tosses the light bulbs inside the car.
Yes, sir.
And then Mr. Boring asks you specifically where he can see the car seat. And your answer was, what did you say?
Correct.
And what you testified to then was that when he reaches in, he comes up, he opens the door, and as he's reaching in, he kind of turns his head a little bit. He's in there, he has a clear view. He kind of turns his head and then just tosses the light bulbs into the car.
Yes, sir.
All right. So you agree that in July of 2014, when specifically asked, can he see the car seat, you responded, he's in there, he has a clear view.
Yes, sir.
All right. And, I mean, just getting right down to it, you're suggesting that when he put the light bulbs in the car, he can see the car seat.
I'm suggesting that when he walks up to the car and opens the door, he has a clear view.
Okay.
As he continues forward into the door frame, he has a clear view. I'm not stating where his eyes are. I'm just stating he has a clear view.
And that little explanation right there, that's not exactly what you told the magistrate back in July of 2014, is it?
But it is, and it was cleared up by yourself on page 90.
Okay.
Because you came back and asked me about it, sir, and it cleared it up then.
I cleared up your testimony. Was there something wrong with your testimony that it needs to be cleared out?
Objection, argumentative, Judge.
All right, well, let's talk about the next time then you testified about this. You recall giving sworn testimony under oath before Magistrate Judge Strauss on January the 8th, 2015 regarding this very issue.
For,
Search warrant, application 0040.
okay,
Do you recall that?
I don't recall that. I know I did take out some search warrants. You said it was July 8th, sir?
No, sir, that is, it was January the 8th, 2015.
January the 8th. Was it one of the flash drives?
I don't recall. $0040.